Right, I'm going to take you on to the next case. I don't like just reading law to you, but what this is our case, right? You're going to like this one. The government are in panic stations. There are two cases going at them. One's a tort and one's about their decision with torture. You're going to like this. When I get to this bit, you're going to go, oh! Listen to this, right? So this case has gone in. The Attorney General, this is why I'm saying you people, not me on my own, right? I'm just a mouthpiece. I love the law. I love England and I love our country and our countrymen and women. I will not stand by and watch our people, that's one of you, that was on their way to meet us at Trafalgar Square being tortured by the British Metropolitan Police. I'm not standing for that. That's why we're going to keep pushing this. And if they think we're going away, this case will either be brought in the United States of America in Texas under universal jurisdiction, or we'll bring it in Russia. Because Russia prosecute their police officers for torture. Now, when I start going through this, you're going to see what I mean. And then you'll see that we have entrapped them. You're going to see how clever we are when we work together as a team. Charles Staples argues that the Criminal Justice Act 1988, paragraph 134, is an incorporated treaty obligation. That's a legal term. And therefore part of English law and international law. It is incorporated into English law. It is international law. It's called UNCAT, the United Nations Convention Against Torture. All of the law that's been used in this case was researched over probably 18 months, the best part of 18 months. This case has been whack, 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 whack. Think about it, read about it. The cases that I've read through, the entire cases, right? Not just reading something that AI throws up to these lazy solicitors and these lazy barristers that work for your tax money that don't know their arse from their elbows. Also argued at paragraph 25 and 26 of this document, listen to this. Attached to this reply are letters and emails between a constituent of England, his MP and the Solicitor General. I quote, "The law officers do not institute proceedings under this legislation but must consent to any prosecution brought under it." Well, you seem to be contradicting the whole case by that one statement, and they've put it in writing. They put it in writing to a constituent who watches this show, who wrote to his MP, Sir Bill Wigan, who then wrote to the Attorney General and Solicitor General and also to the Home Secretary, who have all made these replies, and it's all in this document. So now you've got a group of people telling lies, and then you've got a Freedom of Information request that shows they're also lying. So when this all goes to court, a judge is going to turn around and say, hang on a minute, you can't be telling lies to members of Parliament. That's not what you said in this document, and it's not what you said in that document. If they want to play politics, we're playing the law, and it's called the law of the land. If they want to start telling lies, they're going to get caught out, and they're going to get caught out in the High Court, and if it isn't in the High Court era, it'll be in Russia or it'll be in the United States of America. So here we go, people. From Solicitor General to Sir Bill Wigan MP, page 18 of this document. These letters support this case and support the need for paragraph 135 to be made null and void. This is not about politics, it's about the rule of law. Please see attached appendix. Now, do you want me to take you straight to that page? Might be interesting, I'll take you straight to that page. So let's go to page 18 of this document, page 18. So here is, and you're seeing it on your screen live, right? You're seeing this live on your screen. Michael Tomlinson, KCMP, Solicitor General. How many other groups out there and people pleading guilty because they haven't got no bottle and all they want to do is hold their hand out for a pound note? They're not making any difference to anyone. Tommy Robinson, in a big battle with these people, the Solicitor General and the Attorney General, right? Oh, please send me some money so I can pay my British solicitors and British barristers so they can all shaft you for a pound note. When you got people that put their life and soul into a case. Michael Tomlinson, KCMP, Solicitor General. Attorney General's Office, 102 Petty France. There it is. From Sir Bill Wigan MP. Dear Sir Bill, Torture, Criminal Justice Act. There it is. The law officers do not institute proceedings under this legislation, but must consent to any prosecution brought under it. That's it. The whole of this case is a load of bullshit because they're telling lies. So what we're saying is, well, there's a bit of paperwork where you've said you must consent. Someone's bringing a private prosecution, you don't consent. So what is it? You must consent or you don't consent? Trust me, this gets even better. The grounds for this case of matter, they've tried to come back and say, oh, what's this got to... Let me tell you something. This case is so well researched and they put some panda. She might as well be a panda. If I showed you something else, you'd laugh. Wider interpretation is severe pain or suffering to be adopted as an international law intended, and as did Parliament, else it would have defined. So where the law is silent on severe pain, it means we're leaving it to the jury. That's a matter of fact. And the statement, the witness statement and the video evidence from Charles Staples. So what they've tried to do, this woman, who's a barrister, she's come back and said, oh, this is personal injury claim. You need a doctor to say this. Load of bollocks. This is not a physical person injury claim. The reliance on a doctor for physical injury is not arguable in this case. Skilled use of pain restraint techniques while a person is already handcuffed behind the claimant's back, face down and defenceless, prone position, is evidence of intent. Unconstitutional behaviour and or exemplary or aggravated damages standard is all that is needed. It is a claim of private and corporal right where the victim has special damage. That is the injury. It is for the jury to decide beyond reasonable doubt in a criminal conviction. This is a case where state officials have used unreasonable force which was not necessary and was not proportionate, and they were enforcing government policy, not the law. This definition is torture and must be addressed by a judge and a jury. In fact, in a case in the Midlands, right, so bearing in mind, this woman, this female barrister that they've outsourced it to because they're so busy with all these cases and torture, the first case of torture since 1640, we can't deal with it in-house because we're too busy. Let's think about that. So she said you need to have evidence of physical injury for torture of severe pain. Right, now I'm going to put this to you. In fact, a case in the Midlands with the regional crime group where they used their version of waterboarding whilst handcuffed to the rear, sticking a suspect's head down the toilet and repeatedly flushing. There were no marks, no broken bones, and no doctor to decide injury claims. In another case in 2009, the Daily Telegraph reported the Independent Police Complaints Commission, the IPC at the time, is investigating 30 claims against 11 officers in Enfield Crime Squad in North London, including those of water torture, in which a man's head was allegedly forced inside a toilet bowl as it was repeatedly flushed. So what we're saying is you can cause severe pain to someone, you can cause suffering to someone. Skilled torturers and those trained in pain constraint techniques such as police officers know exactly how to cause you pain without causing physical broken or anything, right? They know how to hurt you, and they do more often than not. A 30-year police sergeant, this is the person that is the primary person, the principal in this case, right? Trained in pain restraint techniques from the riot police, knows what he is doing. The other option was a fixed penalty notice. He and others decided to use violence to the victim's detriment. If this was a member of the public and a boxer using violence, would the courts increase the charge? Yes, and they have. If you're a boxer, if you've got two people, I've told you this before on the show, and they're both in a fight, The boxer's the one who, they'll increase the charge. If you break someone's jaw, you do something, it's with intent. And the reason for that is because you are trained in violence. You know, because you have been trained to deliver that punch, and if you start causing damage to someone, you've been trained to do it. A normal everyday person in the street hasn't, and they take that very seriously. So again, you've got someone who's trained in violence, been trained by your tax pound. So you've trained that police officer. I'll ask the question of the members of the jury. I'll ask you the question. Do you want your money spent on thugs in uniform beating our young people in the streets and hurting them and damaging them when they've done nothing wrong other than stand up for your rights? Do you think it's right that your tax money should be used to train these people in violence and then they use it against you when you are no threat to them whatsoever? You tell me. That's what this part of this case is about. And if they think that their training documents are not going to be brought up in this case, ooh, definitely not. Do you know how many exams that sergeant had to take to get to be a sergeant? Do you know how many exams you have to take in the riot squad? And do you know what the training of the riot squad is? No, I do. And so will that judge when we get in front of it. So the other option was to give him a fixed penalty notice, right? Now, there's evidence of him being asked his name and address on other occasions, and he gave his name and address, they give him a fixed penalty notice, and he carried on. That's exactly what should have happened. But this mob didn't. The police and CPS then maliciously prosecuted the victim, causing immense psychological suffering. People commit suicide on bail. He had to defend himself for a 3-day jury trial, where the judge in that trial actually stated, do you believe he's been tortured? He's not guilty. That judge see the evidence. He see the police officers. He questioned the police officers. He even said, why did you bang his head on the floor when he's handcuffed face down on the floor? And the copper said, listen, it was for his own safety. The jury laughed. This is the front of these people. This is why we should never surrender. And them people out there that plead guilty, they put a nail in our coffin. Every one of them standing out there, oh, I'm standing up for the people. I'm doing it, I'm doing that. No, you're not. Because when it comes to it, you lose your bottle. Paragraph 135 could and does not act as a veto to this incorporeal right, not to be tortured. And if no one has access to justice via the courts and a jury using Criminal Justice Act 1988 paragraph 134, it is a pretended law. Lord Millett, paragraph 19 of the grounds of the Judicial Review, no rational system of criminal justice can allow an immunity which is coextensive with the offence. They hate the fact that I've got that in there. They hate the fact that I've found that. And said, listen, one of our court judges, our Supreme Court has said it, right? You can't do it. And they're sitting there saying, they're trying to tell us this is totally without merit. There is a wealth of antecedents of the police reaching the bar of prosecution, but the law never having been applied. In fact, Sir Mark Rowley has stated in a video interview with Sky News and an open letter to the Home Secretary asking for more powers. It is the view of the claimant, Sir Mark Rowley, does not need more powers. All that is needed is to remove and make void the Criminal Justice Act 1988 paragraph 135. They simply prosecute torture. This case underscores the unlawfulness and causation of the veto within paragraph 135 of the Criminal Justice Act 1988, as well as a significant constitutional limitation on rights concerning private prosecution. Parliament has removed the claimant's entitlement to a grand jury. The courts have revoked the claimant's right to private prosecution. Additionally, Parliament has deprived the claimant of accessing laws predating 1688, including the right not to be tortured, 1640, by illegitimately allowing the repeal of Section 3 of the Bill of Rights, Convention Parliament. Prior to this veto, paragraph 135, the claimants could prosecute torture. As it stands, no case can be put to a judge, private or otherwise, without the permission of the Attorney General. The usurpation of a jury is covered in the grounds. Furthermore, you have altered the interpretation of Section 2 of the Bill of Rights of 1688, which originally stipulated that these rights could not be altered post-convention Parliament, unlawfully giving Parliament the subversive right of veto on constitutional rights, in effect allowing Parliament to proclaim itself as sovereign. Parliament cannot legislate against our Convention Parliament rights. The repeals were an unlawful subversion of an Englishman's rights, essentially bestowing Parliament with the unconstitutional authority to modify fundamental rights. Consequently, this action is effectively bestowed upon the state immunity to torture subjects within the realm of England. These rights represent my birthright, Act of Settlement 1701, Section 4, heir rights, incorporeal rights. In consideration of Sir Mark Rowley's public admission, one officer has faced 11 misconduct hearings over sexual harassment, assault, fraud and other allegations. Some cases were proved, others dismissed, but they were dealt with individually. He wasn't fired and he's still serving in the Met. And his statement, we've been slacking a bit, removing less than one a week, maybe 40 or 50 a year. Based on this report, which clearly says that we have been far too soft, there must be hundreds in the organisation I need to get rid of. Some of them are unethical and don't deserve to be a cop and don't deserve to wear the uniform. And some of what they're doing, in many cases, criminal. It is crucial to emphasise the highlighted phrase. And some of what they're doing, in many cases, is criminal. The police say that they're serious about rooting out so-called bad apples. But what this data tells us is that the system itself is enabling and facilitating the behaviour of dangerous officers. This statement is supported by an independent investigation of the complaints process. The police are in effect a judge in their own cause, and this is creating a system of state abuse. The public and the claimants are at significant risk of torture. Last year, 23 individuals, members of the public, died in England and Wales due to direct police contact during arrest, with 5 occurring during restraint. The situation remains of utmost concern. The reasoning behind the case on R versus Gurja, this is the Supreme Court. An argument are laid out in the grounds. It is crucial to understand that no prosecution or belt and braces veto. The state is now 2 options for suppressing torture trials. This conflicts with international law. The claimant seeks both government options for suppression of torture cases to be removed. This is not difficult to comprehend. It is obvious and may be enhanced by an oral hearing. There are thousands of examples of police using false and malicious prosecution. If the court would like, the claimant could enter them into evidence. This includes those already highlighted in the grounds and more. For example, a police surgeon using his state official status to sexually assault 33 police women in Norfolk. Operation Stornoway investigation report confirms this, although the police have now removed the report and its findings from Norfolk Police website. Gotta try and find it. The fact this offending took place within a police force and that 2 inquiries did not result in criminal action being taken against O'Neill is concerning, said Norfolk Police Chief Constable Simon Bailey. Hugh O'Neill was a sexual predator who operated in plain sight using his professional role as a police surgeon to abuse the trust of the very people who are expected to protect others from such abuse. In most cases, they are not addressed at all. In a few cases, a disciplinary hearing has been used even when they have clearly broken the law to international standard of torture. The government's position is this case is totally without merit. When a trial judge has already put to a jury unlawful force as torture and that the prima facie evidence of a victim's statement, personal testimony, who is willing to give evidence in chief and a video of the crime exists and has ostensibly been viewed by the Solicitor General and the Governor General. totally without merit is effectively acquiescing to the continuation of torture. Paragraph 35 of the grounds for judicial review and Lord Cornhill's analysis. The government's position is Criminal Justice Act 1988, paragraph 135 is not a veto. If that is the case, why would they argue against this application for its removal? In effect, it is ineffectual pretended law and must be removed. If it does act as a veto, then paragraph 134 is pretended law. If, as the government's position, they must allow these prosecutions, why is there a permission clause in the Attorney General? The government argues that the CPS deal with the allegation and evidence. Whatever they decide, they would not intervene. If the Criminal Justice Act 1988, paragraph 135 was made void, trusted solicitors and barristers around England and Wales could bring private prosecutions against the police officers. They would put these cases in front of a trusted judges and juries. It would be for a judge in his capacity as a judge to issue proceedings. The facts would be placed before a jury. Please see additional evidence from the constituent MP to Solicitor General. Solicitor General's replies. Jurisdiction. This is a claim of right under common law jurisdiction. The common law control statute covered in the grounds. To suggest that the law lords have no power or right to intervene suggests we are administrative legal system, not a common law one, i.e. political constitutionalist argument, parliamentary sovereignty, versus a legal constitutionalist argument, separation of powers. A common law constitution with statutory and non-statutory rights, access to ancient laws and customs with remedy through the courts of the rule of law. The government's position is that the police are not a special class. If they are not a special class, then allow a judge and jury. If there are many circumstances that arise during the trial for torture, they would have the procedural benefit of an appeal if convicted. Interlocutory appeals during the trial, just like anyone else, and of course we all have the benefit of a jury and a not guilty verdict. The government states that it defends and rejects the claimant's entire position. I find this incredulous position. All the law cited in the highest calibre legal positions that lend weight and credibility to the claimant's case. Appendix correspondence between Sir Bill Wigan MP on behalf of Paul and Solicitor General. See Freedom of Information request. So not only have you got all of this information there, all of the emails between them, the whole discussion, which is going to cause them a serious problem because they've made admissions of that. Right Honourable Chris Phillip, MP, he's been involved. Michael Tomlinson. These are official letters coming back. And this is what I'm saying about people doing what they've got to do. The law officers do not institute proceedings under this legislation, but must consent to any prosecution brought under it. That's not what they've been doing. You've got the Freedom of Information request that I put in, and many of other bits and pieces coming on. They're saying they've never refused the request. Refused, closed, withdrawn, no investigation. 6 have been refused. And then over here, so 6, so 9 has been refused. What we're saying is, we're saying to a judge, someone's telling lies here, and there is a veto. What we're saying is we want that veto gone. We're members of the public, and this person who's standing before you now ain't gone out on the streets rioting. Right? He's brought it before the law courts. And he's standing up, and he has the right to do that. He has standing. He is a victim of state torture, where state officials have abused their position and they have used the power of the police to enforce the government's policies of lockdown. When he had the right to stand up and say, no, I'm not having it. That's it. And he did it peacefully. That's what I'm saying. So I'm hoping my passion didn't get in the way of explaining that too much. But all I'm saying to you is we ain't never going to surrender. We're going to keep pushing this. I'm an Englishman. Charles Staples an Englishman. English Bulldog is an Englishman. They've got the arsehole to keep pushing forward, and so have we. As a group of people, we are being successful. We can only but try, people.